Today, we're going to talk about operating agreements, LLC agreements, and why they matter, what they are important for, what provisions are necessary to include. So this is sort of just an outline of what we're going to talk about today. First off, what is an LLC agreement? Why do you have to bother having one? What are the specific benefits of having the agreement, and the most important provisions? And at the end, I have a couple of stories or cases that might give an example of why some of the things in the agreement are so important to have to avoid conflict and such. So this is just an outline of what we're going to go through today. So what is an LLC agreement? Well, first of all, what is an LLC? An LLC is a limited liability corporation, which is just a different form of, and a different entity that you can use to govern your business. It's like a corporation or a partnership. An LLC is a little different in the way that it's taxed, and is a little bit of a simpler entity, which is why so many people choose to use it, especially with a small business. And the LLC agreement is the governing document for the operations of the company. It governs internal affairs like how members interact with each other. In a corporation, you're called a shareholder as an owner of the corporation. In an LLC, you're called a member. And so the LLC agreement is between the actual organization and its members. So the provisions within it will govern the internal operation of the company between members and between the LLC business itself. It sounds kind of funny to say that, but the business itself is considered its own member. And so it is its own party to the agreement, as well as each of the individual members. And it's important because this is the document you will go back to and look to when you have an issue within the organization, whatever the issue is, and this will give you guidance. So sorry about that. I'm going the wrong way. There we go. Why bother to have an LLC agreement? Why bother to have something in writing? And can you run your business without it? You most certainly can run your business without this particular agreement. And in fact, many states don't require that you have an LLC agreement. For example, in New Hampshire, the statute goes through a litany of various provisions that you should include when you do have the agreement. But it is not necessary to have it. In fact, you can just on a handshake or with verbal conversation determine how you're going to run the business, and that's enough. However, in most cases, and we'll see later that that's really not the smartest thing to do. You want to include as much as you can so that when you're running your business, you're running it in a consistent manner. You'll be much more effective in reaching your goals and being profitable. One thing that I should note up front is that the kind of business that you have will also necessarily govern the provisions that you have in the agreement, and you will want to focus on certain things more than others. If you have a business that's manufacturing, or you have a business that's a restaurant, or you have a business that's all, a think tank, some of the provisions may be different. Depending on that. So when you first start to come around to figuring out what you want your agreement to say, you want to think about it in terms of the kind of business that you're actually engaged in. So generally speaking, the benefits of having the agreement are to run a consistent, efficient business, remove conflict, and there can be a lot of conflict between members of an organization, between people on the outside of the organization and the members, and the more that you address in your agreement, the better off you'll be when issues arise in the future. So the main goal is to avoid any future conflict or to reduce it as much as you can. And the third major benefit is really in terms of figuring out how the company is going to be managed. Are you going to have one person managing it? You may have 10 members with one manager, or are all members equally in control of the business and making decisions. So those are the three main benefits to having an agreement in writing then that's specifically enforceable. So within those benefits, these are the provisions that are most important to address specifically. And when you start to create the document, you'll probably be talking to your lawyer, maybe an accountant, or someone who's got a version of some LLC agreement that they saw somewhere on the internet or that someone else had. And that's great. It's a great thing to start from. But the main provisions that you want to focus on for your business are these. So and I'll talk about each of them individually. The equity structure of the business. And that just means A and B form a business, and they're each members, they're each equal members. They've each committed $10,000 to the business for a total of $20,000 to start as capital. That would, for each of them, those are their capital contributions. And so their ownership as members is based on the initial capital contribution. So since it's 50-50, each one of them has a 50% membership interest in the company, and it's equal. It doesn't have to be that way, and it doesn't have to be money that creates the contribution. Some people can maybe donate real estate. Some people might be the thinkers. Some people may be donating mostly sweat equity. It doesn't have to be cash. But the important thing about that is to not monetize, but figure out exactly what the value is for each of those other kinds of contributions. So if you're a sweat equity investor or owner, how much is that worth at the start of the company? And that becomes the percentage of their ownership. And this is obviously negotiated between members and should be specifically stated in the initial document. The ownership percentage that people will have based on their contribution also governs their distributions that they get, whether they cash out of the business or perhaps as an ongoing quarterly or semi-annually contribution or distribution that the company is going to make. It will relate back to the percentage interest that they have. As I said before, it doesn't have to be specifically connected to a dollar amount. Maybe someone is the think tank and also has put in 25% of the cash, so his or her ownership becomes 50 or 60%. And then their distribution would be that. I do want to say, though, that all of this is negotiable. None of it is, be all end all. You can negotiate different percentages in any way you want. If it ever, hopefully would never get to a point where you're in court over anything like this, the main concept that a court will consider is making sure that your distributions, your ownership percentages are fair and equitable based on whatever the contributions were initially. So that's distributions and the way that profits and losses are carved out. I'm going to skip voting and save that for when I get down to management. I didn't organize that very well, I guess. So restrictions on transfer and restrictions on competition. Mostly the transfer provision is important. In many cases, somebody wants to be part of an LLC maybe for a limited period of time, or some event happens in their life and they need to cash out and exit the LLC. How is the LLC going to handle that? Those kinds of situations should be addressed in the agreement as well. If someone passes away, what happens to their interest? Does it go to their heirs automatically? Does it have to go through probate? Do they have a will? Is it addressed in their will? And do the remaining members want anything to do with this person who may happen to inherit the interest? So what typically will happen is, in a specific language in the agreement, you may have a restriction on what people have to do in order to transfer their interest. If you pass away, your interest will automatically be transferred to the remaining members maybe in a pro rata share, or maybe to the managing member. If something happens and you just want to exit the corporation and you want to get paid for your interest, what are you going to get paid? Are you going to get paid the amount of your initial capital contribution, or has time gone on and maybe that the value is a lot less than that? Are you going to get paid less than that? How is that interest that you have that you're going to sell to someone else going to be valued? So one thing that is important is to specifically state that you will have an accounting firm, someone do an analysis of the value of the corporation as it was, as it is now, something not connected to the LLC, so that everybody can be in agreement that it is a fair and equitable value that you're placing on the ownership interest. You may require that the other members get a right of first refusal. Not that they have to purchase the interest, but maybe they have a right to purchase it before anyone else does. Maybe there is a family member who wants to be part of this business, but before they can buy in, the members have to be given the chance to buy the interest in the first instance. And in any of those circumstances, valuing the interest should always be done by an outside entity, so that it's, again, fair and equitable. But those kinds of restrictions are really important to think about up front. Any kind of event that may happen that will have an impact on the ownership of the LLC should be considered up front. Restrictions on competition. If you are, it may not matter depending on the kind of business that you are engaged in, but if you have a business, I keep coming back to restaurant because it's on the top of my head these days. If you have an interest in an LLC or own an LLC that is a restaurant, do you want other members in the restaurant to be able to have an interest in a competing restaurant? Do you want them to be able to work for a competing restaurant? Probably not. And together with that, if after they exit the LLC, if they do, you want to limit somehow hi Beth, limit the amount that they can compete. You want to somehow restrict that. It's important to do that in order to keep your own business alive, the current LLC alive and thriving. You obviously want to protect that. So now on to management and voting. One of the most important things is also choosing who is going to manage the organization. Will it be managed by one single manager who is appointed and voted into that position by all members, or is it going to be managed collectively by all of the different members? And together with that is the issue of voting. If you have 5 or 10 members and they're all collectively running the organization, there's no manager appointed, it's important to dictate what issues and decisions need to be voted on, and whether the vote has to be unanimous, if it has to be a majority. And the types of decisions can be really impactful on the success of the business. If you are making a decision that impacts the bottom line, who do you want to have power and authority to make that decision? Everybody, or just one person? Or do you want to have a unanimous vote? So in many cases, there is a manager, and especially when there are several members, that's appointed or elected as the governing person, and they have specific responsibilities and also specific decisions that they will be responsible for making on their own without having to interact with the rest of the members. However, even if you have a manager, there will probably be certain decisions that you're going to want a vote from all of the rest of the members as well. So those are things that are most important when you're trying to put together an agreement like this. And you can see, I think, how in certain circumstances, the conflict that might arise if you don't have these things addressed and they're left up in the air, it can get pretty messy, and it can be disruptive of the business and perhaps even cause the business to fail. So getting this stuff agreed on upfront is really the most important thing you can do to make sure you're successful. Oh, I think I missed compensation. I just wanted to mention that because if you do have a manager that is appointed, in most cases, they're going to want some kind of compensation for taking on a management role. And that's something else that you want to address and specify in your agreement. And it can be something that is fluid. In other words, they start out with a certain compensation and maybe annually it's reviewed by all members, and upon a unanimous agreement, it increases by 5% each year. They probably will have a review by all members of their performance and how they're operating the LLC. So all of that, again, is something that you want to make sure you address in this agreement. So I think I probably have been pretty emphatic about the things that you should address. If you don't address anything else and you leave a lot of things, mundane things, to the side, the main things that you want to include are anything that involves decision making, who's doing it, what those decisions are, and they will again change depending on the kind of business that you're in. Different decisions are more important for different kinds of businesses. So you want to try to anticipate that as you write this up. And then the transfer of ownership is also probably the other the other primary provision, in my experience anyway, that can cause trouble down the road. So you want to make sure you can, again, anticipate what sorts of events may happen and make sure you address different options and how you want to restrict those events. So if you don't do anything else, focus on these two things. Before I launch into my little examples here, does anybody have any questions or anything they want to interject? Anything of particular interest?
Yeah, I have a question, Karen.
Hey, hi, how are you?
Good, how are you?
Good.
Yeah, thank you for that presentation. That was really good. I guess my question would be kind of what comes first, kind of the chicken or the egg type question is someone, when they start a business, do they kind of, come out with a product or a service or whatever it may be, and they see if it basically works out, creates revenue, and then create an LLC? Or is it they have an idea, they create an LLC, they do all, they make it official and all that kind of stuff with operating agreements, and then they roll into it? Because I always just wonder what happens first, and then how do you, if the LLC comes later,
Mm-hmm.
how do you, I guess, make sure you are do it above board and pay your taxes, all that kind of stuff?
Right. In my experience, it's best to set it up right at the start. If you have any idea or inclination to start a business with another person that you think is going to be at all lucrative, then the best thing to do is to form the LLC, get your agreement in place, make provision. And I should say too that some things you won't be able to anticipate. That's just the world. But the most that you can, depending on the kind of business you have, you should try to dictate. So I think it's best to set it up right from the start, and then you're all squared away. I will also say that, again, things changed, and as your business grows, people may enter it, people may exit it. You may get very busy. You may become extremely profitable, change the focus. You can always amend your agreement later on for changing circumstances. So what you initially start with isn't what you're going to necessarily be what you'll end with, but you definitely can change with the times, and as your business changes, amend the agreement.
Okay. And you would definitely recommend probably hiring somebody to, like, if you had a business idea, hiring somebody to basically go through this process with you?
Yeah, I mean, you can have an attorney do it for you for sure. It isn't, my focus is New Hampshire. Are you in New Hampshire or are you somewhere else?
I'm in Greenville, South Carolina.
Yeah, I thought you were somewhere in the South. Every state is a little different about how to actually register an LLC. It's usually not very difficult. The Secretary of State will have a form that most people, especially with a small business, will fill out with, with their handwriting, submit it for a small fee, and you're created. That's all it takes. And then the actual LLC agreement itself is probably a little more cumbersome and requires more thought. You might want to have an attorney help you out with that. But it's not a difficult process, especially with an LLC. It's such a common form of ownership these days, especially for small businesses, that it isn't very difficult to form.
Okay, cool. Thank you.
You're welcome. Anybody else?
Karen, could you maybe define what a member is and what disbursement is for those that may not immediately recognize what those terms are?
Sure. Like in a corporation, a shareholder is an owner of the corporation and they have a certain percentage of ownership. In an LLC, a limited liability company, the member is equivalent to a shareholder. So the member is the one who holds an ownership interest in the LLC. I'm sorry, what was the second part of your question?
The follow-on was another term around disbursement.
Disbursement, yep. In that, with disbursements, I'm mainly referring to profit and loss distributions, if there are any. In a brand new small business, there probably aren't any. And in fact, in some cases, the LLC agreement may want to require that any extra profit not be dispersed to a member, but reinvested back into the business, as opposed to having it dispersed pursuant to whatever their percentage interest is as a membership interest.
Cool, thank you.
You're welcome. I'm just making sure I'm not going over my time here. So I have a couple of examples of where there have been trouble. Trouble has arisen because there either hasn't been a sufficient agreement, or the anticipation of events was way off base in the end. And so the first one is about a couple of college kids who wanted to start a gaming business. And they had an idea for inventing a new platform for games. And they formed an LLC thinking that that was the right thing to do, which it was from the get-go, and had an agreement in place. And at the start, they each had $10,000 to put into the business. So they each deposited their $10,000 equally. They each had a 50% ownership in the LLC. And in their agreement, they didn't really anticipate the success or failure of the business. They just thought, well, if someone wants to get out of the business, then they'll get their contribution back, and that's it. So if somebody's out, they get their $10,000 back, and then the other member is the sole member, or perhaps another person buys in. But what they didn't anticipate was being very successful and going from a $20,000 company to a couple of $1 million dollars in their profit and the value of their company. And of course, at some point, one of them wanted to leave voluntarily. And so the other person, the other member, said, okay, that's fine. I'll pay you your $10,000 and I'll take your interest, and that's it. And so my big question is that very fair? Who's that fair to? And is that an equitable distribution of not proceeds, but an equitable distribution of an ownership interest? It's probably not. And if they were to fight about it in court, I would imagine that a court would be much more equitable in determining the amount that the buyout should really be for. But if you were to go by the strict terms of the agreement, then he or she would get $10,000 and they'd be on their way, and the other person would be the remaining member of this, big, huge company worth a lot more money. So the example, really, on my point here is to think about what might happen in the future and try to prepare for it up front so that you don't run into that kind of an issue. That's one example. The other example surrounds fiduciary duties that members have to each other in an LLC. And I'll start by saying what the fiduciary duty is. It means that you have to be loyal to the LLC and that all your actions in the business should focus on the best interest of the business and of the members within it, but not on yourself. And that is a term of art that's used in a lot of different ways legally, and it does apply to a limited liability company, just like it does in any other kind of corporation or other entity. So if you have an organization that has several members, they each have this duty to protect the interests of the company. And if they don't, and they can prove, someone can prove that they have violated their fiduciary duty by, in this example I'm thinking of, by selling an idea that the group had to another outside person for a lot of money without permission from the other members, that's an example of a breach of a fiduciary duty. They will be liable to the LLC for whatever the loss is that they've incurred. So it's important to recognize and maybe even specifically state in your agreement that all the members agree that their first and foremost duty is to act in the best interest of the corporation or the LLC before anything else, so that all of their interests are sufficiently protected in the first instance.